Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Party list group Komunidad ng Pamilya, Pasyente at Persons with Disabilities or P3PWD ran for and secured a party list seat during the May 2022 elections. After proclamation, its first nominee, Grace Yaneza, took her oath before a regional trial court judge. But before she could assume office on June 30, 2022, she and four other nominees resigned on June 7 to 10. Yaneza said she resigned to take care of her sick daughter who had stage 3 cancer. Another nominee resigned to help in her husband's business, while the others either simply cited personal reasons or did not say at all why they tendered their resignations. On June 14, 2022, the party list group submitted to the Commission on Elections the withdrawal and resignation of its 5 nominees, nominating instead 5 new names, including former COMELEC Commissioner Rowena Guanzon, who had just retired from the poll body on February 2 of that same year. COMELEC approved the withdrawal and later the substitution, but another party list group, Duterte Youth, questioned before the Supreme Court COMELEC's approval of the substitution for having been done beyond COMELEC's deadline for substitution due to withdrawal set on November 15, 2021. Guanzon took her oath of office before a Court of Appeals justice on June 27, 2022, and submitted her oath to the House of Representatives. But on June 29, or a day before assuming office, the Supreme Court issued a temporary restraining order. Now, the main issue the court has to resolve: did COMELEC commit grave abuse of discretion in allowing the substitution of P3PWD's nominees? Hi, I am Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 31st of January 2025, and today we discuss the rule on substitution of election candidates, particularly among party list groups, in the context of the case of Duterte Youth versus COMELEC, GR number 261133, decided on August 20, 2024, penned by Associate Justice Ricardo R. Rosario. And joining us is Attorney Luie Tito Guia, member of the Philippine Judicial Academy, Department of Constitutional Law, and former Commissioner of the Commission on Elections. Hi, Commissioner Guia. Welcome to the Supreme Court Podcast.
Hi, Attorney Mike. Honored to be here.
Right, great to have you with us, sir. Let's talk about this rule on substitution. Under the laws on elections, who can substitute for a candidate and when can they do it?
Well, the usual application of the rule on substitution has to do with candidates. And it is only members of political parties can be substituted by another member of the same political party. And the grounds for substitution would be death, incapacity, and withdrawal. Under the Omnibus Election Code, substitution or withdrawal and substitution can be effected up to midday on election day. Okay. However, the COMELEC came up with resolutions saying that if the ground for substitution was the withdrawal of a candidate who have initially filed a certificate of candidacy, then the deadline for substitution was advanced a few or several months for the election.
Mm-hmm. In this case, I think it's November 15,
Well,
2021.
it can change every election actually.
Mm-hmm, mm-hmm. There's a different rule if the reason for substitution is either voluntary, meaning the candidate withdrew,
Yes.
or if, on the other hand, it's involuntary if the person died or is incapacitated.
Yes.
That can still be done by midday of the election day.
Yes.
Does this rule, Commissioner Guia, apply to party list representatives?
Apparently, yes, because the Commission on Election also adopted a resolution that says if reason for substituting nominees for party list system of representation is on account of death and incapacity, then the deadline is on the midday of election day. However, if the ground for substitution of nominees would be a withdrawal of nomination or consent to the nomination, then it is usually fixed at the same day that the substitution for candidates belonging to political party is fixed. So that's usually November as well.
Okay. So essentially, the rules or the deadline set by COMELEC is the same, whether it's for party list or for any other position for a particular election period.
Yes.
Now, Commissioner, in cases where substitution is brought about by voluntary withdrawal of the nominee, should there be a valid reason for withdrawing? I mean, can a person, a candidate, just decide one day, I no longer want to run, therefore I'm withdrawing, and because I want to, the COMELEC has no choice but to approve it?
Well, the Supreme Court in the case of Duterte Youth versus P3PWD versus COMELEC, it said that there need not be any reason for a valid reason for withdrawal. In fact, the Supreme Court can only take note of the withdrawal of a nominee if the reason, well, yes, it can only take note of the withdrawal of a nominee, a voluntary withdrawal.
Now, in the case of P3PWD party list group, there were various grounds cited by the nominees for withdrawing. For instance, there's illness, the need to assist the husband in his business, or to take care of the child who has cancer. Is the COMELEC in that case in a position to actually say that's not a valid ground for withdrawal?
Well, according to the same case, there is no authority on the part of the COMELEC to inquire into the reason of the withdrawal of nominees. So, as I've said earlier, I mean, the COMELEC can only take note of the withdrawal effectively.
So the withdrawal is not prohibited. What would be the acts that are prohibited under the Party List Act?
Well, once the list of nominees have been submitted to COMELEC, and these are usually submitted upon the filing of the certificate of intent to participate in the party list system of representation, what can be done is to alter the order of the nominees in the list submitted to the COMELEC or to change the name of the nominees. So those are the only things that cannot be done.
So for instance, your first nominee cannot be changed by the third nominee or substituted by a third nominee.
That's right. That's right.
So the only ground for them to be substituted is if there's really either a withdrawal or they were incapacitated or if they died before the election day.
Yes, and it's also very important that the substitute would have to come at the end of the list.
Okay, so you can go down the list of nominees before you can get somebody from the outside to fill in the vacancy. I see. In this case, Commissioner Luie, how significant is the timing of the substitution? Because I note that the substitution of the nominees took place between June 7 to June 10, 2022, or after Election Day, but before assumption into office on June 30. So in terms of the timing here, the substitution, there was already an election, and then they had the substitution of all the nominees, including the first nominee who was supposed to take that seat, the one seat that P3PWD party list won in that election. So in terms of time, how significant is this?
Well, according to the Duterte Youth case, the commission itself provided a deadline for substitution of nominees, and that would be November in case when substitution is by reason of withdrawal of someone who has already been nominated. If the reason for withdrawal were death and incapacity, then that would be midday of election day. So definitely, substitutions that take place after the election would already be, according to the Supreme Court, in violation of the COMELEC's own rule. And that in the same case, the Supreme Court said that COMELEC does have the power to fix the deadline for or filing substitution or effecting substitution. Another thing is that there is a section or there is a provision in Republic Act 7941, and that has something to do with substituting a sitting member of the House of Representatives or a party list representative who is already occupying office. And remember, the start of the term of office of Congress is noon of June 30 following the election. So at the time that the substitution was effected in this case, there was yet no term of office. Thus, there can yet be no vacancy that would allow a replacement by virtue of Section 16 of Republic Act signed 7941.
For this particular case, because the substitution came before the term of office, assumption of office, we cannot apply Section 16 because that only applies to a sitting member of the House of Representatives. So therefore, the rules of the House of Representatives on replacing a vacant seat will apply. So what will apply here is Section 8 we've been talking about, the three grounds for replacing a nominee in a party list group.
Correct, Attorney Mike. That is precisely what the Supreme Court said in this case.
What about the contention of P3 PWD party list that the deadline set by COMELEC is mandatory before the election only, but not after the election? Is there some merit to that?
Well, according to the Supreme Court, there's no merit to that argument because the purpose of setting a deadline for substitution has to do with the need to inform the people of the nominees that the party list organization contesting the election came up with. That's also something to do with the right of the people to be informed of the candidates themselves. In this case, while the candidates effectively are the parties or organization participating in the party list system of representation, it is important as well for the public to know who the nominees are. Now, if you allow substitution after the election, then that objective that would not be achieved. And so the Supreme Court said the rule which says that matter of procedures or matter of form or procedures which are mandatory before election may be considered directory after the election, when you know who the winner actually is already.
Okay, so even though the court recognizes that supposedly, ideally, you vote for the group, the party list group, the reality is that you will also vote for that group depending on who the nominees are. And that's a consideration.
That is what the majority decision or majority opinion of the Supreme Court actually said. No? That's important for the people to know who the nominees are because it becomes part of the process of their decision making on how they could make their choice.
So there's an argument raised here, Commissioner Guia, that the law itself did not impose a deadline for substitution of nominees. And in fact, in his dissenting opinion, Justice Alfredo Benjamin Caguioa said it was ultra vires for COMELEC to set deadlines on substitution of nominees for party list groups because the law did not actually state a deadline, it did not indicate a deadline. Can the COMELEC actually impose a deadline?
Well, the Supreme Court, at least the majority opinion of the Supreme Court, said that they can actually fix the deadline pursuant to their power to enforce and administer election law. So it's an inherent power of an administrative agency to implement and to realize and to make sure that the objectives of the law is realized. And the Supreme Court went further by saying that the voters being informed of the list of nominees of a party list is something that is intrinsic in the party list system of representation law, and therefore COMELEC was merely doing its job, performing its mandate to implement the law.
But how different is that situation, Commissioner Luie, from the situation where there's a deadline imposed by law and COMELEC moves the deadline? So for example, there's a PARM election and COMELEC decides to move the holding or the conduct of the election despite the specific date specified under the law. In that particular case, would the COMELEC be violating the law? And how different is that situation from the situation here, where there's no deadline imposed by the law, but the COMELEC imposed such a deadline?
Well, in the case of changing the deadline or changing the schedule of the election, that goes into the very nature of elections and goes into the very intent of the Constitution to hold elections on a fixed date. And then the Supreme Court, in the case of Makalintal versus COMELEC, actually cited Universal Declaration of Human Rights, which states that elections should be held on a regular interval, and that is something that COMELEC should be, Congress and COMELEC should be observing. And while in this case, it's just a question of implementing what the intent of the law is. The intent of the law, according to the majority opinion court in this case, is for the voters to be informed fully of the nature of the party list organization that they're voting for, and part of the nature, of course, would be the list of nominees that they submitted to COMELEC.
There's an argument raised here by former COMELEC Commissioner Rowena Guanzon, who was trying to substitute as the nominee of P3 PWD party list, that the Supreme Court actually, in a previous case, Angkos versus Duterte Youth, allowed the substitution of Duterte Youth party list nominees after the conduct of the 2019 elections. So she's now saying, if you allowed the substitution in Duterte Youth in 2019, why not allow it here? But what was it about the COMELEC's approval of P3 PWD substitution of nominees that the Supreme Court considered to be grave abuse of discretion?
Well, in this case, according to the Supreme Court, there's different, cause of action, different, there's no similarity of cause of action, there's no similarity of parties, and therefore there is no res judicata insofar as the Duterte Youth case is concerned. And by that, the Supreme Court said that the dismissal of the Angkos case cannot be made to apply to the case of P3 PWD. In addition, the Supreme Court said that there was some kind of observed that there was undue haste in deciding the case of Duterte Youth, or at least the case that was then pending before COMELEC, and cited as well the dissenting opinion in COMELEC of Justice Ferulino, which outlined the process by which the case was decided. The Supreme Court concluded that the proceedings shows that there was undue haste in deciding that case, evident, where, of course, grave abuse of discretion becomes evident, according to the Supreme Court.
The main decision, Commissioner Guia did not actually consider the actions of wholesale substitution of nominees of P3 PW party list as a sign of bad faith. It was Senior Associate Justice Marvic Leonin who mentioned that. But do we take it to mean, as a takeaway from this case, that if there's a wholesale substitution of nominees after the election, before taking office, that's an indication that there's something irregular that's going on here, and that cannot be done similarly in other cases in the future? Is that a plausible, or is that a let's say reasonable conclusion that we can gain from this case?
Well, the majority opinion itself mentioned the fact that it is a gap in the law that there is no prohibition against wholesale withdrawal and substitution of nominees in the party list system of representation. And the Supreme Court therefore sort of sent a message to Congress that probably this is an area which can be amended. And there was even a citation of the exchange between Chief Justice Gesmundo and Chairman Garcia, where Chief Justice Gesmundo asked Chairman Garcia that COMELEC may consider raising this issue before Congress. So there is a gap in the law that needs to be addressed by the legislature.
Yeah, there was one other argument here raised by former Commissioner Guanzon, and that's the fact that she had already taken her oath. And so she was saying, I've taken my oath, therefore the jurisdiction of that case now belongs to the House of Representatives Electoral Tribunal and not with COMELEC. What was the court's reaction there?
Well, the Supreme Court said that though she might have been proclaimed, taken her oath, but she has not assumed office. Okay? In fact, the Supreme Court said that the temporary restraining order it issued actually prevented her from assuming office. And added to that, of course, the Supreme Court cited a communication from the House of Representatives itself, which said that Commissioner Guanzon has not been able to assume office as of that point. So the requirement for the HRET taking cognizance of cases like this would include, of course, not only proclamation, taking of the oath of office, but it will also require assumption. And there is yet no assumption of office, at least according to the majority opinion. And for that reason, COMELEC retained jurisdiction over the controversy.
One curious thing here, Commissioner Guia, is that as a result of Commissioner Guanzon not being able to sit as the House of Representative of P3 PWD party list, she could also not be renominated. Why couldn't that be the case? So for example, if that substitution was not allowed because it happened before P3 PWD was able to assume office, at least the representative, why couldn't she be renominated? Why couldn't she have been allowed to assume office? And I note Justice Kagiwa's dissent here that the belated substitution did not affect the qualifications of the individual nominee.
Well, the majority opinion said that what cannot be done directly cannot be done indirectly. So what the majority opinion might have been thinking is that, if Commissioner Gonchon were to be renominated again, then that would render nugatory the opinion of the Supreme Court that the substitution done after election and prior to the start of the term of office was illegal, no? If she can be renominated anyway. So that was how the majority opinion disposed of that issue.
And Commissioner Guia, just to close our discussion, what do you think is our takeaway from the whole case, which could serve as a guide to future party list groups who may find themselves in the same situation when you have nominees withdrawing or dying or getting incapacitated, and you now have vacancies in your list of nominees?
Now, first and foremost, a Supreme Court, or at least a majority opinion of the Supreme Court, validated the power of COMELEC or the authority of COMELEC to promulgate rules, specifically the setting of deadlines. So probably COMELEC in the future can learn from this decision and try to come up with a bit more stringent requirement for substitution. All right, without of course overstepping its authority. Of course, the opinion of Justice Kagiwa is also enlightening. He said that if the law does not allow, why should COMELEC be given that authority? But I think COMELEC will take guidance in this decision as expressed in the exchange during the hearing of this case before the Supreme Court between the Supreme Court and Chairman Garcia, where Chairman Garcia said that he would of course be waiting for how the Supreme Court would decide this case to serve as its guidance in coming up with rules for the 2025 election. And I think COMELEC just did that.
So COMELEC issued a pertinent regulation on this, Commissioner?
That's what I know. It has always been, setting a deadline for substitution of party list nominees has always been very tricky issue in COMELEC. When I was in COMELEC, of course, that has always been a bone of contention even among commissioners. No? But this decision of the Supreme Court would say, of course, would put a nail in the coffin, so to speak, on COMELEC's authority. Recognizing, of course, that there are, should I say, powerful dissent as well.
So, Commissioner, given this ruling of the Supreme Court, can the COMELEC now address the loopholes in the law when it comes to substitution without having to amend the law? Or is it really necessary for Congress to amend the law on substitution?
Definitely not, of course, no, because I think the Supreme Court itself was very clear in saying that these are things that the COMELEC may not be able to do anything about except to probably push for changes or amendment in the law that will actually fill the gaps here. That wholesale substitution has been seen as an action that skirts the intent of the party list system of representation. However, there has been no unanimity in regards to that position, and it would always be best for Congress to revisit the law and fill the gap. But on the other hand, of course, under the party list system of representation, which is a system of proportional representation, voters actually vote for the party and its ideology and its platform, not necessarily its eventual nominees. So the responsibility of coming up with the right nominees that will actually push and articulate the advocacy of that party would be the party's responsibility, and that would be a matter of political accountability of the party versus the voters.
And on that note, thank you, Commissioner Guia, for the thorough discussion.
Yeah, my pleasure, Attorney Mike. Thank you.
If you wish to read the full text of the decisions we discussed today, you can go to the Supreme Court website and e-library and search for GR number 261133, Duterte Youth versus COMELEC et al., August 20, 2024. Here's Tiff Atendido Beltran, Supreme Court Information Officer, for this week's Roundup.
At the Supreme Court this week, the Supreme Court has upheld the authority of the Energy Regulatory Commission, or ERC, to require consumers to pay bill deposits as security for their electric bills and affirmed it as a valid exercise of the ERC's rate fixing power to ensure the economic viability of electricity distributors. In an en banc decision penned by Senior Associate Justice Marvic MVF Leonin, the court denied the petition filed by Neri J. Colmenares and representatives of various party list groups challenging the ERC's authority to allow distribution utilities, such as Meralco, to collect bill deposits from their consumers. In another decision, the court ruled that foreign currency deposit accounts are exempt from estate tax under Republic Act No. 6426, or the Foreign Currency Deposit Act of the Philippines. In a ponencia written by Associate Justice Ramon Paul L. Hernando, the SC's First Division upheld the claim for an estate tax refund filed by the estate of Charles Marvin Romig, an American national residing in Puerto Galera, Oriental Mindoro. The SC emphasized that the 1997 National Internal Revenue Code, a general tax law, did not expressly repeal the specific tax exemption granted by RA 6426, a special law. The court clarified that a general law cannot override or revoke a special law without a clear and explicit repeal provision. In another case, the Supreme Court ruled that overseas Filipino workers may still exercise parental authority or sole custody over their children despite being assigned abroad. In a decision written by Associate Justice Josep Y. Lopez, the court's second division awarded to an OFW based in France the sole custody over her minor children, with provisional custody to the children's grandmother living with them in the Philippines. Ruling on the petition for habeas corpus filed by the children's father, the court held that the mere fact that a parent was an OFW does not deprive him or her of the right to exercise parental authority or sole custody over their children. In this case, the court awarded sole custody to the mother, who was still able to supervise and take care of her children despite being overseas. This as opposed to the children's father, who was found to be unfit due to his habitual drinking, smoking, and past violent behavior. On January 30, 2025, the Office of the 2025 Sharia Bar Examinations, or SSBE Chairperson, Associate Justice Antonio Tico Jr., has announced the opening of applications for the 2025 SSBE. Application requirements and venue assignment procedure may be found at the Sharia Special Bar Bulletin No. 2. The application period shall be until February 28, 2025 at 3 in the afternoon. Also on January 30, Chief Justice Alexander G. Hesmundo served as the keynote speaker at the 20th National Convention of Lawyers organized by the Integrated Bar of the Philippines in Cebu City. The Chief Justice stressed that technology should only be used as a tool to enhance delivery of justice. Similarly, Senior Associate Justice Marvic MVF Leonin spoke about artificial intelligence as a means to augment, not replace, human intelligence. Meanwhile, Associate Justice Ami C. Lazaro Javier discussed recent cases decided pursuant to the Code of Professional Responsibility and Accountability, while Associate Justice Josep Y. Lopez gave updates on criminal law and procedure. The three-day convention is themed From Milestones to Horizons, Strengthening the Future of the Legal Profession. On January 31, 2025, the Supreme Court held a Regional Mental Health Summit for Judicial Region 7 with the theme Nurturing Mental Health to Enhance Efficiency and Productivity in the Judiciary. Held in Cebu City, the summit was led by Chief Justice Alexander G. Hesmundo and Associate Justice Mario V. Lopez, working chairperson of the SC Governing Council for Mental Health. This initiative is part of the SC Cares program, in line with the court's commitment to promoting wellness among members of the judiciary under the Strategic Plan for Judicial Innovations 2022 to 2027, or the SPJI's target outcome of efficiency. Among the topics discussed were judicial burnout and managing mental health issues in relation to work, family, and relationship. Judges were also given an opportunity to share mental health practices for efficiency and productivity. And that's your Supreme Court this week. I am Tiffany Doblatran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, Threads, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, Jay Rempilio, and May Sibal as researchers, Gary Enriquez and Victor Laranio as sound editors, and Tyke Flores and Jerome Batumalake as web editors.